if you want to start us off.
Thank you. Good morning, everyone. Welcome. It's so exciting that we have a large turnout this morning for this webinar, topic recreational marijuana in the workplace. I'd like to start out by welcoming, thanking our partners. These association and partnerships do a lot for our webinars. They share them with their members, and we'd like to thank them. So ABC, North Dakota, Minnesota, Doherty and Dahl, Lakes Area Manufacturing, MPMA, NRASP, Tri-State Safety Association, and the HBA of Fargo-Moorhead. Since we have such a large attendance this morning, we'd like to introduce ourselves. My name is Melissa Olheiser. I'm the Regional Director out of the Dakotas office over in Fargo. And our presenter today is Tom Revenue. Tom, do you want to introduce yourself?
Thank you, Melissa. Yeah, Tom Revenue. I'm with Littler Mendelson, and I think the slide speaks for itself, so I won't spend a lot of time other than to say I've spent a lot of time working with employers on labor and employment matters throughout the country.
Thanks, Tom. And just a background, we had presented this topic back in March, Tom and I, and the overwhelming ask to have a follow-up now that things have passed through legislature is why we wanted to give some answers and have this opportunity to just connect, just be a conduit for information. Maybe there'll be a lot of questions coming up, and I'll give you guys some housekeeping here in a minute, but just a little bit about who OECS is for those of you that are new and haven't heard much about us. We provide safety consulting services to companies throughout the Midwest. We do everything from meeting with you, doing a facility assessment, to helping build your culture. That could be through training and compliance programs or just on-site assessments, really whatever the client needs. So we look at that as being your total safety solution. We have two offices, the Twin Cities corporate office, information is on the lower left. And then we have a Fargo office for our Dakotas region. Information is on the right. I will have my contact information again at the end of the presentation. So with that, I believe we are going to go into, we know that this is going to be a very high question webinar. So we are not going to ask questions until the end because I feel as you go through the webinar and hear the information, a lot of things will get answered. So if you will please put your questions into the chat, we'll try to leave some time for Q&A. And when we do that, we will read through them. But if we don't get to all the questions, we will save the chat. I'll get that to Tom and he'll follow up with those individuals directly. Another item, we are unable to share this presentation, so we cannot send it out, but we do record it. And within 48 hours, we do have it on the OECS website. You can also contact myself or anyone on our info@oecscomply.com to ask for a link. And I believe we are ready to go. So Tom, I am going to turn it over to you.
Thank you, Melissa. And good morning to everyone. With regard to today's presentation, just talking about the new law in Minnesota as it relates to recreational marijuana, I will say that as a practicing labor and employment lawyer, and I've practiced for almost 30 years now, I never believed in a million years that we would be faced with the legalization of recreational marijuana. And of course, it creates a whole host of issues for employers, particularly employers who have employees that work in safety sensitive positions. But even beyond that, if you have employees that are working with children or you're in the healthcare industry, it creates a whole host of issues with regard to how do we ensure that our employees are working safely. And like I said, I never believed that we would have this law, but we are where we're at. And there are quite a few other states that have adopted or who have legalized recreational and medicinal marijuana. And of course, as many of you know, Tim Walz, our governor in Minnesota, had announced a few years ago that if a recreational marijuana law ever hit his desk, he would sign off on it. And of course, we have a picture of Governor Walz signing into law the new law. on recreational marijuana. And of course, Jesse Ventura is standing right behind him. And Governor Ventura was also pushing for the adoption of recreational marijuana in Minnesota. So what does it mean? And here's, the interesting piece is that this law that deals with recreational marijuana is extremely comprehensive. It's a very lengthy law. It's 320 pages, the bill that was ultimately passed. And essentially what it provides is that adults in Minnesota can possess up to 2 ounces of cannabis flower, and they can grow up to 8 cannabis plants in their home with 4 flowering plants at any given time. Now, to put that in context, somebody did a study with regard to if you had the flowering plants at your home, how much would that entail? And the statistics I've seen is that you could grow up to 2 pounds of cannabis at home. And that 2 pounds, as I understand it, you could roll 2,200 marijuana joints as an adult. So a lot of recreational marijuana can be grown in somebody's home. And of course, this law has a tax when we ultimately have entities that are selling recreational marijuana. There'll be a 10% tax. 80% of the tax will go to the state, and then the 20% will go to the local. And the legislature estimates that every 2 years, the sale of cannabis will lead to about $120 million in tax revenue. Of course, as part of this law, individuals who had misdemeanors will be automatically expunged from the misdemeanor offenses as it relates to recreational marijuana. And if you had a felony related to recreational marijuana, there's a board of review to review whether to expunge the felony. Of course, because this is such a comprehensive law, there are 15 types of licenses for cultivators, retailers, and what have you. And for folks who are interested in ultimately becoming a seller of recreational marijuana, and you can't make this up, but essentially Minnesota, like a lot of states who have legalized recreational marijuana, they've said if you want to sell marijuana, you have to enter into a peace agreement with a union in order to sell, which is code for you're going to have to enter into a collective bargaining agreement with a union if you want to sell marijuana. And then again, I can't make this up, but there is a position within these cannabis shops. It's called a quality control tester. And those quality control testers can test up to 3 times a day at the cannabis shop to make sure that the marijuana is in fact good marijuana. And the law led to the development of what is referred to as the Minnesota Office of Cannabis Management. And you can see there are a lot of divisions within this office, educational pieces with regard to for adult consumers or for medical cannabis patients, for people interested in starting a business, the general public, in expungement of criminal records. And so there's a whole host of information available as to the Minnesota Office of Cannabis Management. And then just from a timeline, and a lot of people have asked questions with regard to this. Well, so the bill is signed on May 30th. Adults could start possessing and growing marijuana at home as of July 1st. And as of August 1st, we start seeing that the criminal penalties are being expunged. And then, of course, the reason most of you are here today is really to learn about the drug testing provisions. And so essentially, as of August 1st, there are changes to the Minnesota Drug and Alcohol Testing in the Workplace statute, which I'll spend a lot of time talking about. And there are other things that are taking place as a result of this law, but you can see that when it comes to full retail operations, we're not looking at having the businesses selling marijuana until early 2025. And so there's a lot of folks who have been saying that there's going to be a lot of issues with regard to the selling of marijuana illegally in Minnesota between July 1st of this year and when the full retail operations take place. So there's going to be a significant black market that hasn't been addressed through these bills. Now, what this means as far as recreational marijuana becoming available is, as many of you know, Minnesota has essentially what is referred to as a lawful product statute. And that statute has been in existence for quite a few number of years. And essentially what it says is that as an employer, you cannot take adverse action against an individual as a result of their lawful use of a consumable product. And if you do take adverse action against them for the lawful use of a product, you can face wrongful discharge claims, which can lead to reinstatement and back pay. But essentially, cannabis, which includes the edibles, is now considered a lawful consumable product in the state of Minnesota, regardless of the federal status. And as many of you know, even though marijuana has been legalized in Minnesota, it is still an illegal drug under federal law. So in essence, under the law that was just passed, it made it very clear that unless failing to do so would violate a federal law or cause an employer or business to lose monetary or licensing related benefits, an employer cannot refuse to hire an applicant or discipline an employee for off-duty cannabis. And now keep in mind that lawful consumable product statute does not apply to individuals during work hours or during work premises. So you can still ban employees from using cannabis, just like you can ban them from using alcohol during working hours or on working premises. But in essence, it will lead to interesting scenarios for employers where, let's say, the receptionist, who is a non-safety sensitive person, comes into your office on Monday morning and tells you about the weed that he or she smoked over the weekend. Now, your immediate reaction under the prior law would be, well, there's a problem here. Whereas now, as of August 1st, if somebody's smoking weed and they're in a protected status, so to speak, you couldn't take an adverse action against them. And as I said, essentially what that means is if you violate the Minnesota lawful consumable product statute and you terminate someone because of the lawful use of marijuana, whether it's medicinal marijuana or recreational marijuana, it can lead to essentially a wrongful discharge lawsuit if you terminate that person. And that person can seek their lost wages and benefits as a result of the violation. And additionally, it allows for attorney fees and costs. And of course, this dovetails into where a lot of employers have been conducting pre-employment testing. And oftentimes employers have been, for their pre-employment testing, they've been testing for marijuana on their pre-employment drug panels. And I'll talk about what that means going forward with regard to your drug testing policies. But essentially, we get into cannabis in the workplace and how do we address cannabis in the workplace and what rights do employers have and how do we address this? So I want to be absolutely clear because this seems to be a source of confusion for employers. I want to be absolutely clear that as an employer, you are not required to permit or accommodate cannabis use, the possession, the impairment, the sale, or the transfer of those products while the employee is working, while they're on your premises, or when they're operating your vehicles, your machinery, or equipment. So even though marijuana has been legalized in Minnesota, you can still ban the possession or sale or impairment while they're working for them. And in addition, you can enact and enforce work rules prohibiting the cannabis use. Now, if you're going to do that, you're going to certainly going to want to make sure that it's built into a written drug and alcohol testing in the Workplace Act compliant policy. So the law requires that your work rules prohibiting cannabis use need to be built into your drug testing policy. And to the extent that we have attendees on today's webinar, when I refer to DATWA, or the Drug and Alcohol Testing in the Workplace Act, that is the Minnesota statute. That's what it's referred to as, DATWA, or the Drug and Alcohol Testing in the Workplace Act. And of course, when you're enforcing your work rules with regard to impairment, you're obviously going to want to make sure that your folks are trained in reasonable suspicion testing. And I'll talk about that in a moment. But essentially, the way the law is written is that as an employer in Minnesota, you can take adverse action against the employee if, so we take a look at the work-related conduct. So if the employee used, possessed, was impaired by, sold, or transferred cannabis while working, while they're on the premises, or operating vehicles, machinery, equipment, you can take adverse action if the employee lacks clearness of intellect or control of self that they otherwise would have due to cannabis consumption. 2, you have a cannabis positive result on a confirmatory test. 3, you can take adverse action against them if they have violated your work rules as contained in the drug and alcohol testing compliant policy. You can take adverse action against them as required or if permitted under federal or state law, which means essentially, if you're an employer that has DOT covered drivers, you're going to follow federal law. You're not going to follow state law, you follow federal law. And of course, you can take adverse action if you as an employer will lose federal money, or you'll lose a licensing related benefit if employees are using marijuana during working hours. So let's just touch base on how do you comply with the Minnesota Drug and Alcohol Testing Workplace Act. So a few things to keep in mind, that as an employer, all employers, no matter how many employees they have, if you have at least one employee in Minnesota, then you have to comply with the Minnesota Drug and Alcohol Testing Workplace Act. And as an attorney, I have worked on drug and alcohol testing policies throughout the country. And what I will say is that when it comes to Minnesota, Minnesota has one of the most comprehensive and one of the most employer restrictive drug and alcohol testing policies or statutes in the country, meaning that there's quite a few things that you have to build into your drug testing policy in order to ensure that you are lawfully conducting drug testing in Minnesota. But if you have one employee in Minnesota, you fall under the Minnesota Drug and Alcohol Testing Workplace Act. And an employee is broadly defined as any person working for you, which could include an independent contractor as well. Now, there are caveats with regard to whether you need to comply with the Drug and Alcohol Testing in the Workplace Act. And those caveats are that, first of all, if you are a federal contractor, you're an employer that falls under federal law, whether it's the Department of Transportation, the FAA, the Nuclear Regulatory Commission. Those laws will preempt state laws. So you'll follow the federal law. Of course, there's the Federal Transit Authority as well, regulations. There may be some requirements under state law where you're required to test, and that would also, you'd follow any requirements under state law outside of DATWA, and you'd still be fine. And of course, if you have government contracts that require testing, you'd have to follow the government contracts. And of course, if we have any professional teams online, professional athletes are in their own league. But in essence, professional athletes would be tested in the same manner as they've always been tested. With regard to what the new law means for employers, is it has essentially changed how we do testing. And the easiest way to describe this is really to show you that under the old law, prior to August 1st, when we as an employer were conducting testing, the testing would either be drug testing or the testing would be alcohol testing. As of August 1st, we now have 3 types of testing. We have drug testing, alcohol testing, and cannabis testing. So if you haven't updated your drug testing policy yet, drug and alcohol testing policy, one thing that you're going to want to make note of is that your drug and alcohol testing policy is now a drug, cannabis, and alcohol testing policy for purposes of state law. And as the legislature rewrote the drug and alcohol testing in the workplace statute, essentially they said, look, we're going to define drugs in the way that we have always defined drugs, which is a controlled substance under the various schedules under the Minnesota statutes, with the exception of cannabis, which we're going to exclude cannabis from being defined as a controlled substance. And we're going to define cannabis in a different way. And cannabis under the state law is now essentially defined as marijuana, cannabis metabolites, which you would find in THC or CBD, cannabis flower, cannabis products, the low potency hemp edibles that we're now finding in grocery stores, gas stations, liquor stores are selling the hemp derived consumer products, the beverages and what have you. So cannabis is now its own substance. It's no longer considered a controlled substance for purposes of state law. So with regard to the pre-employment cannabis testing, there are now new restrictions, and those new restrictions are for pre-employment cannabis testing. You can only test for cannabis in certain positions. Under pre-existing restrictions, employers could conduct cannabis testing for all candidates, but the new restrictions are when it comes to pre-employment cannabis testing, you can only do that for certain positions, which essentially is you have to determine whether or not the applicants that you're testing fall under certain categories. So if an individual is in a safety sensitive position, which I'll cover momentarily, you can conduct a pre-employment cannabis testing. You can also conduct pre-employment cannabis testing for face-to-face care positions. And when I'm referring to care positions, I'm referring to healthcare as well as in the education world, care of children or facing the children. You can continue to conduct the pre-employment cannabis testing. Of course, you can still test if federal or state law requires that you conduct the testing. DOT covered drivers, you can also do the pre-employment cannabis testing. And of course, if you're a public entity and you have police officers or peace officers and firefighters, you can conduct pre-employment cannabis testing. Otherwise, all other testing of other workers is now prohibited from a pre-employment cannabis testing standpoint. Now, I will say that in my practice, over the last 5, if not 10 years, it was very common for me to get calls from employers with regard to, hey, we want to eliminate pre-employment testing altogether, or we're going to eliminate, or we want to eliminate pre-employment testing just for cannabis. And can we do it? And of course, the first question that I would ask would be, well, why do you want to stop doing the pre-employment testing? And uniformly, the response was that they stopped doing the pre-employment, or wanted to stop doing the pre-employment testing because they had so many candidates that were coming through that were testing positive for cannabis that they couldn't find enough qualified candidates to fill their workforce needs. And so the elimination of pre-employment cannabis testing, that's been around, at least in my world, for quite some time. And I talk to clients every day where, you know, they still want to do testing, or they need to do testing. And one of the significant scenarios where employers want to do the testing or need to do the testing is where they have employees or applicants that they're hiring for what's referred to as a safety sensitive position. And under Minnesota law, essentially the law defines a safety sensitive position as any position in which impairment caused by drug, alcohol, or cannabis usage would threaten the health or safety of any person. And in Minnesota, we don't have a lot of guidance as far as from the legislature or from cases that have really defined a safety sensitive position other than the definition that's on the screen in front of you. And so I think ultimately we're probably going to see litigation with regard to who is considered a safety sensitive position, or who is in a safety sensitive position. And I think there are positions that clearly would fall within the definition of a safety sensitive position. So as an example, if you have an employee who is being hired to work on a construction job site where they're going to be operating heavy equipment, or they're going to be working around heavy equipment, then I think there is a really good argument that they're in a safety sensitive position. I think where you get into, you'll get into some gray areas with regard to how far do you go to define whether somebody is in a safety sensitive position. And what I have suggested to clients is, if you're going to test for safety sensitive positions, and I'm certainly a proponent of doing that testing to protect workers on job sites or protect the employer, I think you have to think about the job description, look at the job description, and update the job descriptions for the employees to make it clear that they are in a safety sensitive position. Because if you're doing testing for, as an example, a receptionist who doesn't drive a company vehicle and shows up to work every day and just answers phone calls, I think you'd be very hard pressed to say that that person is in a safety sensitive position. If you have an individual that drives a company vehicle once a year, I think you might have a hard time saying that person is in a safety sensitive position, but I certainly understand the argument that you'd want to make in that regard. But like I said, I think you have to really think about, if you're doing testing for pre-employment cannabis use, and you're doing it because you believe somebody's in a safety sensitive position, you really have to think about what those job duties are and why you believe that person is in fact in a safety sensitive position. Now, keeping in mind that There's no legal requirement that you do cannabis testing under state law. Obviously, under federal law, DOT covered drivers, as an example, you would have a legal requirement to do the cannabis testing. But whether you do the pre-employment cannabis testing, that's ultimately going to be dependent upon your business. It'll be dependent upon your safety needs, your staffing needs. Certainly, I recommend that before you drop cannabis testing from your pre-employment testing policies, that you check with third parties, in particular, that you talk with your insurers, those that are carrying your general liability or your workers' comp policies, to determine whether or not you should be dropping it and how that could impact you from an insurance perspective. Particularly, if you have employees that are jumping into company vehicles and you're thinking about dropping cannabis testing. But if you do decide to test, keep in mind that you need to meet the requirements. In other words, your employees that you're testing for pre-employment cannabis are going to have to fall under one of the exceptions under the ban of pre-employment cannabis testing. With regard to random cannabis testing, keep in mind that the pre-existing restrictions only allowed random cannabis testing for safety sensitive positions. So if you're a Minnesota employer that is doing random testing for everyone, chances are, unless all your employees are in a safety sensitive position, you may have some issues with regard to whether you're complying with Minnesota law. Additionally, make sure that if you are doing random cannabis testing or random testing for drug and alcohol, that you're using a random selection basis so that everyone has the same likelihood of being selected for a random test. Under the new law, there's no new restrictions for random cannabis testing. Just keep in mind that it is still restricted to safety sensitive positions. And then, of course, you can conduct reasonable suspicion cannabis testing. You could do, under the previous law, you could still do reasonable suspicion testing for drugs and alcohol. You can still do it, and that's regardless of the position. So keep in mind that in Minnesota, even though we have legalized recreational marijuana, you can still conduct reasonable suspicion drug testing in Minnesota for all employees, regardless of what position they're in. So you're not restricted to just doing reasonable suspicion testing for safety sensitive positions or another exemption. You can do reasonable suspicion testing for all employees. Now, if you're going to do reasonable suspicion testing, the law is written in a manner that says, look, if you're doing reasonable suspicion testing, you're doing the reasonable suspicion testing based on the fact that you have formed a belief based upon specific facts and rational inferences drawn from those facts that the employee is either, one, under the influence of drugs or alcohol, two, has violated the employer's written work rules regarding drugs, alcohol, and cannabis. And you'll note that I have an asterisk next to the words violated the employer's written work rules, because remember that your work rules prohibiting drugs, alcohol, and cannabis need to be built into your drug and alcohol testing policy. 3, you can do a reasonable suspicion test based on the fact that the individual has sustained a personal injury, i.e. a work comp injury, or has caused another employee to sustain a personal injury. And then finally, you can conduct what I refer to as a post-accident test, but you can conduct a test where the employee has caused a work-related accident or was operating or helping to operate machinery, equipment, or vehicles involved in a work-related accident. So those are the three or the four scenarios where you can conduct the reasonable suspicion testing under Minnesota law. What I'll note is oftentimes employers will ask questions with regard to, well, how do I know if somebody is under the influence of drugs or alcohol? And what I suggest to clients is that when it comes to reasonable suspicion testing, determining whether somebody is under the influence of drugs and alcohol, I think it's really imperative that you conduct supervisory and managerial training to determine, so they have the tools to determine whether somebody is under the influence of drugs and alcohol. And there are a number of providers that do the reasonable suspicion training. OECIS does the training and can come out to your work sites and actually train your supervisors on reasonable suspicion, identifying where an employee may be under reasonable suspicion for drugs or alcohol. And certainly I recommend that if you are going to send somebody for a reasonable suspicion test, that you ideally have two supervisors or two individuals who have made observations to determine whether somebody may be under the influence of drugs and alcohol. Another point that I'll make, just as I'm talking about reasonable suspicion, is oftentimes I have clients that will call me and they'll say, hey, we have an employee who we believe is under the influence of drugs or alcohol. And so we went to talk to the employee, and the employee admitted to us that right before starting work or during the lunch break, they drank some alcohol, or they smoked some pot, or what have you. And certainly if you have someone who has admitted that they are under the influence of drugs and alcohol, you certainly don't have to send them for a reasonable suspicion test. You can take action based upon their admissions. But just keep that in mind, because if you do send the employee for a reasonable suspicion test under Minnesota law, and they test positive, and it's their first positive test while working for you, Minnesota has essentially a law or provision in the Drug and Alcohol Testing Workplace Act that says you have to offer them rehabilitation for the first positive test. You can't take disciplinary action against them. Whereas if they admit and you don't send them for a test, you can take appropriate disciplinary action without sending them for rehabilitation. And that's something you'll have to talk through with your leadership team with regard to how you want to address those types of issues. But with regard to other cannabis testing scenarios, keep in mind that there are no changes to the treatment program testing. In essence, as I said before, if somebody tests positive for drugs or alcohol or marijuana, before you terminate them on a first positive test, you have to offer them rehabilitation. And that rehabilitation program may mean that those individuals are being sent for periodic testing as part of the program put together by the substance abuse professional. And you can still do that under this new law. Whereas if somebody tests positive, you can still do the periodic testing to ensure that they're not using cannabis. Additionally, I know I have some clients that will conduct drug and alcohol testing for a routine physical exam. And just like the pre-employment testing, there are restrictions. You can only do with a routine physical exam, you can only do the testing in a safety sensitive position or one of the other exemptions. So if you're wondering why I have the safety plus positions, I'm referring to the other positions that are exempt from the changes in the law. So this dovetails into, well, what do you need to do as an employer as it relates to updating your drug and alcohol testing policies? And so just to jump right in, some things to think about and that you're going to have to do is your drug and alcohol testing policy in Minnesota. You're going to have to look at how you define drugs. And oftentimes your drug and alcohol testing policies will list the panel of drugs that you're using or the panel that you're testing for, whether it's the opiates, the marijuana, and what have you. But you're going to have to redefine how you define drugs, because under Minnesota law, cannabis is no longer considered a drug. Additionally, you're going to have to think about the specifics for when you're going to conduct cannabis testing, whether you're going to eliminate it altogether, whether you're going to conduct the testing for safety sensitive positions and the other positions. Obviously, you'll continue to comply with any federal state requirements. You'll also have to consider developing your workplace rules regarding cannabis. And most of you on today's call probably have a work rule that prohibits employees from having or using alcohol in the workplace. And that work rule is can ideally be amended to make it clear that you're also prohibiting cannabis. And so you're just going to add the word cannabis or cannabis related products into your work rules. And as I said earlier, I think now is a really good time for you to conduct training for your managers and supervisors. And that training should include not only reasonable suspicion testing, but we also have to, start educating managers and supervisors with regard to the fact that when we're talking about cannabis in Minnesota, it is now a lawful product. Meaning just like an employee can go out to the bar and, at night and drink alcohol, they can go out on the weekend and go to the bar and drink the hemp consumable products, which is hard for me to really say because I have a strong safety background and I work with a lot of clients that are concerned with safety related issues. But just keep in mind that your managers and supervisors may not be aware that cannabis is now a lawful consumable product in Minnesota, and they're going to have to be educated with regard to some of the restrictions for what we can do with disciplining or terminating employees so we can avoid those wrongful discharge claims. And then finally, I know we have a number of attendees that are on this call where you have operations in a lot of different states and including Minnesota. And it's not uncommon for me to receive a drug testing policy from an employer who is based in Wisconsin, and they've decided to adopt that same policy in Minnesota. And that policy that you're taking from another state more than likely probably isn't compliant with Minnesota law. Minnesota law requires that you as an employer have very specific information contained within your drug testing policy. And so your policy requires that you identify who is subject to the testing, whether it's applicants, whether it's safety sensitive individuals, but you have to identify all the employees who are subject to the testing. Obviously, you have to identify when the testing may be requested or required. And essentially what I'm referring to is, are you doing pre-employment testing? Are you doing reasonable suspicion testing, random testing? The testing as part of a routine physical exam, follow-up testing, return to duty testing. All of that needs to be identified in your drug testing policy to comply with Minnesota law. The law also requires that employees are notified that they have the right to refuse to undergo a test and what the consequences of refusing to undergo that test will be. You also have to identify what, if any, disciplinary action will be taken based upon a confirmatory positive test. So to be clear, Minnesota law requires that any drug testing go through a confirmatory process. So it's not just going through the lab and they do one test and the person tests positive, but they're actually testing that sample or that specimen a second time. Minnesota law also requires that your drug testing policy contain language that the employee has the right to explain a positive test result and any appeal procedures that are available. And I will tell you that prior to this new law taking effect, as many of you know, last July, we had in Minnesota, we had essentially legalized the edible consumable marijuana products or cannabis products. And oftentimes I would have clients that would call me that employee would come back and test positive for marijuana. And of course, the MROs, the medical review officers, don't review whether the lawful consumable product led to a positive test, but rather just would say whether there was a positive test or not. And the employer would say, look, I tested positive because I ate a lawful consumable product. I ate the edibles over the weekend, and you can't take action against me. And of course, that led to some interesting decisions by employers, but most of the employers recognizing that the edibles were a lawful consumable product, even last year, wouldn't take an adverse action. But keep that in mind that you may have those scenarios that arise. And of course, your policy is also going to have to identify any appeal procedures that are available to the employee as a result of a positive test. Keep in mind that in Minnesota, if you do conduct testing, one of the things that you have to keep in mind is that you as an employer must provide written notice of your testing before the testing can actually take place. So employees obviously have to be notified of the test, receive a copy of the policy before the test takes place. And in addition, and this is where I think a lot of employers miss the mark, is you're required under state law to post a notice of your drug testing policy and inform employees that copies of the policy are available for inspection. And before you request a drug test, your authorization for the drug testing, the employee must acknowledge that they've reviewed the company's drug testing policy. Now, you may ask, well, what happens if we don't have all of this information built into our drug and alcohol testing policy in Minnesota? And essentially, if you don't build in all the protections, you have conducted an unlawful test under Minnesota law. And if you test and send some and ultimately terminate an employee for a positive test, you have exposure to a wrongful discharge claim under the Minnesota Drug and Alcohol Testing in the Workplace Act, which is why I'm encouraging you, now is a good time to review and have your drug testing policies updated. And then just a couple final points. Keep in mind that under Minnesota law, within 3 working days after the employee after you've received a copy of the test results, you need to provide a notice of those results to the employee, whether it's positive or negative. And if it's a positive test, you have to tell them that they have a right to get a copy of that positive test result and also the right to explain the positive result within 3 working days of the notification, and or request a confirmatory retest. And then, as I said, keep in mind, Minnesota law requires that you cannot discharge an employee for their first positive test unless, one, they were given a chance to participate in a rehabilitation program, and 2, they refused or failed to successfully complete that program. So takeaways. First of all, keep in mind that these employment provisions took effect at the beginning of this month. So you're required to comply now. 2, as you're thinking through, what do we do with our drug and alcohol testing policy? I encourage you as employers to identify what the safety sensitive positions that you have within your organizations, or any other positions that are exempt under the new provisions. 2, keep in mind that you can't do pre-employment cannabis testing unless the individuals fall under a safety sensitive or other exception under the law, which we talked about earlier. And then 4, I would emphasize again that you do reasonable suspicion training for your supervisors and your managers. I fully anticipate that you're going to see an uptick in employees showing up to work that they appear to be under the influence of drugs or alcohol. And if you're going to send them for a test, you're going to want to make sure that you have actually documented that the person does have the criteria that meet the requirements for reasonable suspicion testing, and certainly that your supervisors or managers that are making that determination have gone through reasonable suspicion training. And then the final point is, obviously, make sure that your testing policies, if they haven't been reviewed since August 1st, make sure that they're reviewed. Make sure that they're updated to comply with the new state law, and certainly make sure that you include in your testing policies the written rules that prohibit cannabis use, possession, impairment during work or while working on machinery equipment for the company. So that's a lot of information in a short period of time. I did want to leave a little bit of time for questions and answers. I know we don't have a lot of time. I think we have roughly 5 minutes for any questions that you may have. And as Melissa said, certainly if you do have questions that we can't get to on today's webinar, we will get back to you as soon as we can. So I'll open it up for any questions that you may have.
Okay, Tom, so I'm going to go through the questions that have been going into the chat throughout the presentation. You might have touched on some, but just to offer some clarity, let's just start at the beginning of these, and then the ones we don't get to, again, we will answer and send out. There is a question. Their company already has a drug-free workplace policy in place that can they continue to test for THC as they always have?
So great question. And when employers refer to a drug-free workplace, I want to be very clear that I have seen employers that have in their handbook, we're a drug-free workplace and we're going to conduct testing. That is not compliant with state law. If you're going to do testing, you need to have a written policy that contains all the criteria that I talked about at the end of today's webinar, because if you don't have that, you're going to violate the Minnesota Drug and Alcohol Testing in the Workplace Act. Additionally, keep in mind that, yes, you can do the testing for cannabis if somebody is, if you have reasonable suspicion criteria, no matter what their position is, but you're going to want to make sure that you do in fact have reasonable suspicion for that type of testing. So hopefully that answers the question.
Okay. Next one, this person, they're a federal contractor, can we still do pre-employment blanket testing for marijuana?
Yeah, good question. So, it's hard for me to say just based on the definition, just by saying I'm a federal contractor, do I need to do the testing? Because it's really going to be dependent upon what your contractual obligations are for the testing. And in addition, it may also be dependent upon whether your employees fall under one of the exemptions. In other words, you have DOT covered drivers, which would require the testing. So it's hard for me to answer that question just based upon the vagueness of it.
Okay. I've got down, can we make all employees' job description include safety sensitive position for our non-DOT employees? I think you did cover that, but if you just want to touch on that.
Yeah, great question. I'd be hesitant to classify all employees as safety sensitive. I know there are a lot of companies that would like to do that. But as I said earlier, if you have a receptionist who is really just answering the phone and greeting your guests, and they're not driving a company vehicle or operating company equipment, I think you'd be very hard pressed to say that they're safety sensitive. And if you sent that person for a pre-employment test, and they tested positive, and you denied them employment as an applicant, I think you would have a wrongful refusal to hire type claim.
Great. There's quite a few questions that were related to safety sensitive positions and descriptions, but those were covered in the presentation. So I'm going to keep going to some other questions in here. Aside from DOT, what other federal, okay, we covered that. Can a company have a zero residual effect rule like alcohol, as is drink and smoke all you want at home, just don't let it affect your performance at work?
Well, that's a loaded question. And I'm hesitant to answer that question because I
Okay.
think that becomes a company specific policy, business decision. And I'm hesitant because I don't know what type of positions that employer has in their
Okay.
business.
Okay. There's actually quite a few questions that are similar to this question I'm going to ask. It says, how does this work with a border city, for example, Fargo, Moorhead, where employees live in Minnesota, but they work in North Dakota, service clients within Minnesota and North Dakota. As a company resides in North Dakota, do North Dakota law rules apply?
Yeah, that's a great question. And I think it's an area of the law that is undeveloped, right? But if you have employees that are working within the state of Minnesota, you're going to have to fall under Minnesota law. So if you're a North Dakota employer and you're conducting testing for employees that are working in Minnesota, you're going to have to comply with Minnesota law. Now, I think the question is asked differently. If I have residents of Minnesota that are performing work in North Dakota, what are my obligations? Well, assuming those employees aren't going back and forth, that they're just working in North Dakota, I would comply with North Dakota law. But if you have those employees that are going back and forth between North Dakota and Minnesota, I'd follow Minnesota law because I think you're going to have some potential issues under Minnesota state law. So hopefully that answers the question.
Perfect. Well, we are out of time for this. And like I said, there's several more. I promise we will get the chat copied. I'll follow up with Tom. We will get these questions answered, but we would like everyone to please participate in our final poll rating this webinar. It helps us determine if we met what you were looking for, if where we can improve on, how can we, get better. Again, your feedback is very important. Awesome. Looks like we had everyone have time to get that in. So just to finalize a couple of things here. If you, Mark, can you go to the next slide, please? And so again, let me see. Sorry. I talked about the questions. Just want to remind everyone there were questions in the chat if we can share the presentation. Unfortunately, we cannot share the presentation. We did record it. The video will be on the OECS website within 24 to 48 hours. You just have to go to the past webinars, and all of the ones that we've ever presented are listed there. This is the contact information for Tom and myself. If you want to screenshot it or take a photo, you can reach out to us if you think of something afterwards. If you need some help with anything, I did want to just reiterate that OECS, thank you, Tom, for mentioning that we do offer a reasonable suspicion training. We offer it in our classroom, which is a virtual, a hybrid, so you can attend in person, you can attend from a hybrid option from your office, and the next one is September 12th. We can also reach out to myself or Connie, and we can schedule something for your company specific. If you have a group that needs this training, we can put something together for you as well. The next webinar coming up is the Violence in the Workplace webinar. It will be September 21st at 11 a.m. It's going to be a great presentation. This has been a high topic, just keeps, hitting the media. It's in our communities. It's not going away. So I think it's wonderful for OECS to touch base with how can we address this? How can companies do assessments and put protocols in place to protect their employees? Just a reminder that we do help in a variety of different fashions with any type of safety solution that you're looking for. So whether that be audits or training, compliance, the contact information is at the bottom. Reach out to anyone on our team. Those of you that are clients or associations, reach out to your associate and see how we can help push the dial on helping you build your culture. I want to once again thank our partners. Without you, we don't get to get this information shared with a lot of individuals. So thank you to ABC, Doherty and Dahl, Lakes Area Manufacturing, MPMA, NRISP, Tri-State Safety Association, and the HBA of Fargo-Moorhead. Tom and I would like to thank you again for attending today. And again, if you have any questions, please reach out to us. Have a great day.